Listen to me carefully because this might bring you peace and save you from paying money you never truly owed. A few months ago, I sat across the table from a soft-spoken woman named Clara, 73 years old, a widow. She had just paid $950 for 4 debt notices she thought were mandatory. The papers looked official. They used legal-sounding words. She said, "I was afraid if I didn't pay, they'd take my Social Security." Clara is smart. She's proud. But fear made her reach for her checkbook. And here's the twist. She didn't legally owe that money. The law let her ignore all 4. But no one had told her. This video is for every struggling senior who has ever looked at a debt notice and whispered, "I don't know if I can afford this." Or worse, "I'm too tired to fight." Because here's what the collectors hope, that you'll be too overwhelmed to ask questions, that you'll pay in silence, that no one will stand beside you. But today, I will. I'm not just a lawyer. I've spent 15 years helping older adults protect what's theirs. And in the next few minutes, I'm going to walk you through 4 debt notices that many seniors feel pressured to pay, but can legally ignore by law. And make sure you stay until the end, because the last one is not only the most manipulative, it's the one I see trapping seniors into paying again and again. So grab a notebook or just listen closely. And if any of this reminds you of something you've experienced, share it in the comments. Your story could help someone else feel less alone. And don't forget to tap that like button so this reaches more people who need it. Now, let's begin with one of the most misunderstood and fear-inducing types of debt notices: time-barred collections for debts so old collectors can't sue you anymore. When Betty opened her mail, she expected a birthday card from her grandson. Instead, she found a $1,800 demand from a law office for a 2010 credit card. She sat at her kitchen table, confused and scared. She said, "I don't even remember that card, but what if not paying hurts my Social Security?" Here's the truth. Many seniors, especially after decades, get hit with zombie debt letters for accounts bought for pennies. This happens when the statute of limitations expires, usually 3 to 6 years from last payment. But under state laws, you're protected. If enough time passed and you didn't restart the clock, you often don't legally owe through court. That's a powerful starting point. From my work, I've seen that many notices threaten lawsuits they can't file due to time-barred status. And yes, it's frustrating, but also fixable. You can dispute the debt. You can request validation. And if you feel unsure, you can ask the collector directly. Can you show me the last payment date and my state's statute of limitations? One study from the CFPB found that 2/3 of people never even tried to validate old debts. But among those who did, over 40% had their claims dropped entirely. If this happened to you or someone you love, know this. You're not causing trouble by asking questions. You're protecting what you worked for. And if a notice like this shows up in your mailbox again, take a breath. Let your lawyer brain switch on. You have time. You have rights. You can do this too. Coming up next, we'll talk about another hidden trap: debt notices for someone else's debt that hope you don't know the law. A week after burying her husband, Laura picked up the mail and saw, "Estate of Tom owes $2,400 immediately." Her hands shook. She whispered, "But I didn't sign anything. It was his card." This is where grief meets legal manipulation. Countless seniors, especially widows, are quietly pressured to pay off a loved one's debts they don't legally owe. And in moments of sorrow, guilt becomes currency. Here's the law. Unless you co-sign the loan or are legally bound to the account, you are not responsible for a deceased person's debts. Not as a spouse, not as a child, not as the surviving relative who gets the mail. But debt collectors know how to blur that line. They'll send letters addressed to the estate, but speak as if you personally owe it. They lean on your confusion and even more on your kindness. I've seen it too many times. One woman I worked with received notices about her brother's medical debt. No shared account, no agreement, just her last name. She almost paid it until we asked one simple question: Can you show us the signed agreement with her name on it? They couldn't. The letters stopped. Emotionally, this hits deep because when you've lost someone, you're not just managing grief, you're fighting to keep your stability. And behind every demand letter is that silent fear. If I don't pay, am I dishonoring them? Let me say this clearly as your lawyer. Grief should never come with a balance due. You are allowed to mourn without being financially hunted. The FTC confirms this. Debt collectors cannot make you pay from your own money unless you're legally tied to the account. If they try, demand written proof. Ask for the original agreement. If they don't have it, you can walk away. No shame, no guilt. You can do this too. One letter, one call, one boundary at a time. Next, we'll talk about something even more personal. Debt notices for services you never ordered or agreed to. One quiet Sunday after church, Nora got a message about a $650 alarm monitoring contract breach. She sat frozen. She remembered a salesman checking smoke detectors months ago, but didn't remember agreeing to pay anything. This is where politeness becomes a trap. Seniors, especially those living alone, are often targeted in these informal service claims. A favor quietly turns into a demand. A helping hand becomes a bill. But here's the truth. If there's no written contract, no terms, and no proof, it's not legally enforceable. Now, I'm not telling you to ignore your conscience. If you truly agreed to pay someone, integrity matters. But if someone brings up a service months later with no signed document, no text, no email, no bank charge, labeled as that service, then they carry the burden of proof, not you. I once helped a retired nurse who was hounded by a $640 home warranty claim from a phone call she didn't recall authorizing. No written note, no agreement, just pressure, and the threat of credit damage. We asked for proof. They had none. It ended right there. Emotionally, this kind of situation stirs up deep fears. Will people think I'm dishonest? Will this ruin my reputation? Am I being forgetful? It's okay to ask these questions. It's also okay to set boundaries from a legal lens. Here's the key. Verbal service claims are hard to enforce unless documented clearly and proven. Courts typically don't uphold casual sales pitches without dates, terms, and signatures. And no, politeness is not a binding agreement. If someone claims you owe for a service visit, here's what to do. Stay calm. Ask for documentation and don't pay out of pressure. You can even say, I don't recall agreeing to these terms, and I need full documentation before deciding. You have every right to pause, to protect your peace, and to honor the truth, not just their version of it. You can do this too. One quiet boundary could save you hundreds. Next, we'll talk about a debt notice that shows up even when you didn't use the service after moving, and why you don't always have to pay it. 3 months after moving into her daughter's home, 75-year-old Grace opened forwarded mail to find a $450 gas bill from the apartment she left behind. She'd already canceled her account, read the final meter, and handed over the keys. But now she was being told she owed for weeks of service she never used. This kind of thing happens all too often. Seniors downsize, move in with family, or go to assisted living, and weeks or months later, a utility bill follows them like a shadow. And here's the truth. I want you to hear clearly. If you no longer lived at that address and the service wasn't under your control, you are not legally responsible for paying it. Sometimes, utility companies fail to close the account properly. Other times, a new tenant lets the service continue, hoping the former resident will just pay out of confusion or guilt. I helped Grace, who received a $380 water bill for her old apartment 2 months after senior housing. When we asked for documentation, the company couldn't show meter readings under her name post cancellation or any service request from her. The bill disappeared the moment they were held accountable. Here's what you need to do if this happens to you. Ask for written proof of the dates of service, meter readings, and account holder during your tenancy. Provide a copy of your move-out notice or lease end. And most importantly, never pay a bill just to avoid the hassle. That payment could be seen as admitting responsibility. Under consumer protection laws in most states, providers must verify charges before collections. You have every right to dispute in writing. You can do this, too. One calm letter protects your peace. Now let's look at the most heartbreaking type. When the debt notice wasn't real at all, but a scam designed to prey on your trust. Last winter, Evelyn opened a letter stamped Final Notice. It said she owed $380 for a home warranty she never signed up for. There was a customer ID, support phone line, even her address. It felt real, but it wasn't. This is how scammers work now. Their notices look official, their emails polished, their voices calm but firm, and their favorite targets, seniors who value doing the right thing. The danger isn't just the money, it's the self-doubt they plant. What if they're right? That fear of missing a payment, that worry you're irresponsible. Here's the legal truth. If you didn't sign up for the service, you don't owe anything. Scammers use public info to make fake debts seem real, and once you pay once, they keep coming back. I always tell clients, trust your gut. If something feels off, don't rush. Ask yourself, did I ever sign anything? Did I talk to this company? Why gift cards or wire transfers? Legit companies don't demand weird payments or threaten without docs. One tip, ask for business license and company name. Look online. Complaints or no trace? Trap avoided. FTC says seniors lose over $3 billion yearly to fraud. Phantom debt, big part. But it doesn't have to be you. You have the right to question, delay, verify. You still have control. Please share this with someone you love. And now, let's bring everything together because you deserve peace, not pressure. Today we talked about time-barred debts you can ignore, others' debts pushed on you, phantom services, moving bills that chase you, all aimed at helping you take control. Because here's the truth, you weren't raised in fine print and auto billing. You came from handshake time when bills made sense. If confusing now, not your fault. Slow down, ask questions, say, I need time. You have rights. You have power to protect peace. One change makes big difference. If helped, share with neighbor, sister, friend. Your wisdom protects savings. Tell us in comments, which notice will you check? I'm not just lawyer. I believe your calm and dignity never monthly sacrifice.